My name is Lee Offord. I am 34 years old. 6 months ago, my mother tried to take my autistic son away from me in family court. She brought a fake CPS report. She brought 4 witnesses who swore under oath that I was an unfit mother. She brought a pediatrician's evaluation with numbers that did not match. She even brought my own sister. What she did not bring was the truth. And what she did not know was that I had spent 8 years working inside the same legal system she was trying to weaponize. The family court judge read online from my attorney's brief. Then he looked at my mother. Then he called for the baif. What happened inside that courtroom changed my family forever. Welcome back to Calm Drama Stories. This channel shares family stories where the quiet ones speak last and speak loudest. If you have ever been underestimated by the people who were supposed to love you, you will understand every word of what comes next. Drop a comment and be sure to subscribe. EMTT was 6 when all of this started. He had brown eyes the color of tree bark and a way of tilting his head when he was listening that made him look like he was solving a puzzle nobody else could see. He was autistic, diagnosed at 3.5 just after the divorce. And every single day since that diagnosis, I had built his world around what he needed. His mornings ran on a clock only he and I understood. Noise-canceling headphones went on at 650. Oatmeal cut into squares, not circles. Backpack zipped by 720. Bus at 7:42. If the bus was late by more than 4 minutes, we drove. No exceptions. On the refrigerator, I kept a color-coded schedule. Blue for therapy, green for school, yellow for doctor appointments, red for IEP meetings. I had binders for each color. 3 ring binders with tabbed sections and dates highlighted in the margins. My coworkers thought I was organized. The truth was simpler than that. Organization was the only thing standing between my son and chaos. His ABA therapist, Dr. Kendra Solis, told me once that EMTT had made more progress in 2 years than most children on the spectrum make in 5. She said it during our quarterly review, sitting across from me with his progress chart spread out on the table. She said it the way someone states a fact, not a compliment. EMTT did not speak much. 20 words at 3, 212 at 6, but he communicated. He hummed when he was happy. He pressed his forehead against my shoulder when he was tired. He lined up his toy cars bumper to bumper when something at school had gone wrong. You just had to learn his language. I had learned it. I was fluent. My mother's name is Diane. She was 62 years old, retired from a church administrative position she had held for 19 years, and she had never once in my life let me make a decision without her commentary. She chose Kevin for me, my ex-husband. They met at a church fundraiser when I was 25, and by the end of that same evening, Diane had already planned our first date. She picked the restaurant. She picked what I should wear. When he proposed 14 months later, she picked the venue, the flowers, and the guest list. I was not consulted on any of it. When I filed for divorce 3 years later, Diane told every woman in her Bible study group that I was abandoning my family. She told our relatives I was unstable. She told Kevin's mother that I had episodes. She never asked me why I left him. She did not need to know. In her version of reality, I had simply malfunctioned. After the divorce, Diane's visits to see EMTT always followed the same pattern. She arrived with a gift. She set it on the counter. Then she walked through my house like an inspector from a government agency. She opened the refrigerator. She checked the bathroom floor. She looked inside the medicine cabinet and counted the bottles. My mother did not visit. She audited. I noticed something else during those visits. She started taking photos on her phone, not of EMTT, of the kitchen counter, of the laundry pile. Of the spot on the bathroom tile I had not gotten to yet. She thought I did not see, but I had been watching her watch him for 34 years. I always saw. I stopped explaining my divorce to her after the 3rd time she called it a tantrum. Gerald offered. My father was 64, retired contractor, big hands, quiet mouth, the kind of man who let his wife do the talking and then repeated whatever she said in a deeper voice so it sounded like authority. The Sunday dinner happened 7 months before the courtroom. Diane had invited me. I should have said no. EMTT sat at the table for 12 minutes before the television overwhelmed him. Diane had the volume up. Game show. Applause and buzzers every 15 seconds. EMTT pressed his hands over his ears, rocked forward, and started humming the high-pitched note that meant his nervous system was shutting down incoming sound. I reached for his headphones. Diane reached for the remote and turned the volume down by 2 notches. 2, like tapping the brakes on a freight train. EMTT's humming escalated. He pushed his plate. The fork clattered on the floor. Diane sighed the way she always sighed when EMTT did anything that did not look like the other grandchildren at church. I picked EMTT up and carried him to the hallway. Gerald followed me. He leaned against the wall, arms crossed. Lee, I was putting the headphones on EMTT. His breathing was slowing. You can't handle a difficult child as a single mother. He did not say it like an opinion. He said it like a verdict. Rehearsed, practiced, the words too smooth for a man who usually spoke in half sentences and shrugs. I looked at him. He looked past me at EMTT. I did not argue. I did not explain. I carried my son to the car, buckled him into his seat, and drove home in silence. That night after EMTT was asleep, I sat in my kitchen and replayed Gerald's words. Not because they hurt, because they sounded scripted. When EMTT was born, something went wrong. A medication error during delivery caused a reaction that led to oxygen deprivation. 47 seconds. That was how long my son went without adequate oxygen. Long enough to change the trajectory of his brain development. Long enough to generate a medical malpractice case that took 18 months to settle. The settlement was $640,000. It went into a special needs trust. I was named sole trustee. That money paid for EMTT's ABA therapy. 3 sessions a week at $215 per session. It paid for his sensory equipment, the weighted blanket, the compression vest, the swing I installed in the spare bedroom. It paid for the occupational therapy that taught him to hold a spoon, button a shirt, and tie his shoes with modifid laces. And it was earmarked for his future. Housing, job training, whatever he would need when I was no longer here to cut his oatmeal into squares. I managed the trust the way I managed everything in my life, with spreadsheets, receipts, and quarterly reviews filed with the court. Diane had mentioned the trust fund 3 times in the past year, each time wrapped in concern. How is the money being managed? Do you have a financial advisor? Shouldn't family have some oversight? What if something happens to you? That is a lot of money for one person to manage, Lee. I had answered each question the same way. It is managed according to the court order. It is audited annually, and it is none of your business. She had stopped asking after the 3rd time, but she had not stopped thinking about it. $640,000. That is what my son's future was worth on paper. To my mother, it was worth more than that. It was worth lying for. It came on a Tuesday. I remember because Tuesdays were quiet. EMTT had Therapuntal 4:30, and I used the silence to prep case files for Margaret. The mailbox had the usual electric bill, a catalog I never ordered, and a manila envelope with a return address from Benson County Family Court. I opened it standing in the driveway. Petition for grandparent custody, rights filed by Diane M. offered, and Gerald R. offered. The first paragraph read like a script from a bad legal drama. The minor child requires a stable 2-parent household. The custodial parent has demonstrated a pattern of inability to manage the child's special needs, resulting in documented concerns from medical professionals and family members. I kept reading, standing there in the driveway with the sun going down behind the maple tree and the electric bill still in my other hand. The petition cited 4 supporting declarations, 4 witnesses who would swear under oath that I was not fit to raise my own son. It cited a pediatrician's evaluation, stating EMTT needed a more structured environment with multiple caregivers. It cited a CPS report filed active pending investigation. I read the petition line by line. My paralegal brain did not shut off just because my heart was racing. I found 4 procedural errors before I reached the signature page. Wrong statute, a 2019 case citation that had been overturned in 2021. A misspelled judge's name, and a filing date that fell on a Saturday, which meant someone had backdated it. The last line of the petition read, "We are doing this for EMTT." I folded the envelope, walked inside, set it on the kitchen counter. Then I called the one person who would know exactly what to do. Margaret Barrett had been practicing family law for 28 years. She was 56, gay-haired, and had a voice that could make a courtroom go silent just by saying, "Objection." She was also my boss. I had been her paralegal for 8 years. I organized her case files, drafted her motions, and sat beside her in courtroom after courtroom, watching parents fight over children who just wanted to go home. I knew family law the way a nurse knows a hospital, not from the textbook from the floor. I brought the petition to Margaret's office the next morning. She read it in 90 seconds. I know because I watched the second hand on her desk clock while she read. She set it down, took off her glasses. They filed under the wrong statute. They cited Harper versus Monroe, which was overturned 2 years ago, and they misspelled Judge Calloway's name. She paused. Also, your mother's lawyer clearly does not practice family law. I sat in the chair across from her desk, the same chair where I had sat for 8 years taking notes on other people's custody battles. "Margaret, can they actually take him?" She looked at me the way she looked at clients who asked that question. Steady, no false comfort. Not if I have anything to say about it. She took the case pro bono. "You have saved me 10,000 billable hours over 8 years. I owe you at least one case." Margaret did not say, "Don't worry." She said, "We need their phone records by Friday." That was when I stopped being scared. Not because the fear went away, but because Margaret had replaced it with a plan, and plans were something I understood. Thursday morning, 2 days after the petition arrived, I was making EMTT's oatmeal when someone knocked on the front door. Rosa Delgado, CPS caseworker, short dark hair, clipboard, lanyard with a county ID badge, professional, polite, and standing on my porch at 7:15 in the morning. M offered, "I am here regarding a report filed with Child Protective Services concerning your son, EMTT." She said it the way someone reads a script they have read 1,000 times. I recognized that cadence. I had heard it in courtrooms. I let her in. Rosa walked through the house the way Diane walked through it, except Rosa was actually authorized to do so. She checked the kitchen, the bathroom, the bedrooms. She opened the refrigerator and noted its contents. She looked at the medicine cabinet and wrote down what she saw. She spent 10 minutes in EMTT's room. The sensory swing, thuited blanket folded on the bed, the color-coded schedule pinned to the wall, the shelf of therapy tools organized by type and session date. She asked about the headphones. I explained. She wrote, "Age-appropriate sensory accommodation." She observed EMTT eating breakfast, oatmeal, squares, spoon in his right hand. He did not look up. Rosa wrote something else. Before she left, she stood on the porch and said something that was not in her script. Between us, Ms. offered the timing of this report and the custody petition. That is something I have noted. I closed the door, locked it, sat on the kitchen floor for 2 minutes. Then I stood up and called Margaret. 2 attacks in 48 hours. The petition was the opening move. The CPS report was the follow-up. My mother was not just suing me. She was building a case. If this story is already making your blood pressure rise, you are not alone. What my mother did next made the CPS report look like a warm-up. If you want to see how this courtroom battle ends, keep watching. And if you have not subscribed yet, now is a good time. Margaret filed a motion to obtain the full CPS report narrative. It arrived on a Monday, 6 pages, single-spaced. I read it at my desk during lunch. I had read hundreds of CPS reports for Margaret's cases. I knew what real ones looked like. The language was clinical, vague, observations without conclusions, because caseworkers are trained to document what they see, not what they assume. This report was different. It alleged unsanitary living conditions in the kitchen and bathroom. It alleged the child had been left unattended for extended periods. It described visible bruising on the child's upper arms consistent with rough handling. Every allegation was specific. Specific rooms, specific dates, specific injuries described in specific anatomical terms. That was the tell. Real CPS reports do not read like that. Real reports say the home appeared cluttered or the child seemed withdrawn. They hedge. They qualify. They leave room for interpretation. This report read like a closing argument. Somebody had written it with a verdict already in mind. I recognized the phrasing. The child was found in distress in the living area. My mother called every room a living area. The kitchen was the living area where we eat. The den was the living area where we sit. Nobody at CPS uses that term. Nobody outside my family uses that term. I set the report on Margaret's desk. "Your mother wrote this," Margaret said. Not a question or dictated it. Margaret pulled a yellow legal pad from her drawer. "We need to find out who filed the report, and we need to find out what they were promised in return." My mother taught me to clean a house. Then she described that same house as filthy to a government agency. Discovery produced the 4 sworn declarations attached to the petition. Margaret spread them on the conference table like evidence in a homicide case. Declaration 1. Brooke offered, age 29. My sister, I have personally witnessed the child crying for extended periods while Lee ignored him in another room on at least 3 occasions during my visits in January. Declaration 2. Pauline Dressler, age 58, my aunt Diane's sister. During my visit to the home on March 12th, I observed unexplained bruising on the child's upper arms. Declaration 3. Derek Dressler, age 31. Pauline's son, my cousin. I have observed Lee consuming alcohol excessively on multiple occasions in the child's presence. On one occasion, she appeared unable to care for the child. Declaration 4. Dr. Harold Moss, retired pediatrician, family friend, golf partner of my father's for 15 years. His evaluation stated, "The child requires a more structured and stable environment, ideally with multiple consistent caregivers." I read each one. I read them the way I read depositions, looking for the seams, the places where the stitching shows. January. She had not been to my house since October. Pauline's declaration said March 12th. She lived in Tampa, 3 states away. Derek's declaration said multiple occasions. Derek had not visited my home in 2 years. Dr. Moss's evaluation was dated January of this year. He retired from practice 18 months ago. I read Brooke's declaration last, read it twice. My sister, the girl I shared a bedroom with for 16 years, the girl I helped apply to college, the girl whose first car I co-signed because our parents said she needed to earn it on her own. She signed it under penalty of perjury, 4 declarations, 4 lies, and I could prove every single one of them wrong. Margaret filed 3 motions in one afternoon. Motion 1, dismiss the petition on procedural grounds. Wrong statute, overturned case citation, backdated filing, misspelled judge's name. Standard stuff. Any competent family law attorney would have caught these before filing. Diane's lawyer was not a competent family law attorney. Motion 2, request for sanctions under Rule 11 of the Federal Rules of Civil Procedure. In plain language, Rule 11 means this. If you lie to court, you pay for every hour the other side spent proving you lied. Motion 3, subpoena for the phone records of Diane offered, Gerald offered, Brooke offered, Pauline Dressler, Derek Dressler, and Dr. Harold Moss. While Margaret handled the courtroom, I handled the research. It was what I was built for. Aunt Pauline claimed she visited my home on March 12th. I pulled her credit card statements through Discovery. Delta Airlines, Tampa to Philadelphia, March 28th, 16 days after she claimed to have seen bruises on my son. She was not in the state on the date she swore under oath. Brooke claimed she visited in January. I checked her Instagram account. 5 months of posts, not a single one from my house, but there were several from Diane's house. Captions like family planning session and doing what is right. Dr. Moss's evaluation was dated January of this year. His medical license records showed he stopped practicing 18 months ago. The evaluation referenced tests and observations from a visit that never happened. We did not need to prove they were lying. We just needed to prove they could not have been telling the truth. There is a difference. Proving someone lied requires intent. Proving their story is physically impossible requires a calendar and a credit card statement. Margaret lined up our evidence the way she lines up her closing arguments. One fact at a time. No wasted words. Brooke and I shared a bedroom until I left for college. Twin beds separated by a nightstand with a lamp we both claimed belonged to us. She was 5 years younger. I braided her hair for school. I proofread her college essays. I taught her how to parallel park in the grocery store parking lot on Sunday mornings when it was empty. When she turned 21, I co-signed her first car, a used Honda with a dent in the passenger door and a radio that only picked up AM stations. She cried when I handed her the keys. She said I was the only person in the family who treated her like an adult. Now she had signed a sworn statement saying I was an unfit mother. Margaret found out why. During discovery, a financial document surfaced, a letter from Diane to a mortgage broker dated 6 weeks before the petition was filed. In it, Diane offered to co-sign a home purchase for Brooke. The letter referenced upcoming changes in family custody arrangements that would make co-signing financially viable. My sister sold her testimony for a down payment. I did not call Brooke. I did not text her. I did not write her a letter explaining how it felt to read her name on a sworn declaration that called me neglectful. The silence was deliberate because a silence was the one language my family never learned to speak. It made them nervous. It made them wonder what I was doing. What I was doing was building a case. I could forgive my mother for being controlling. That was who she had always been. But Brooke chose this. She was 29 years old. She had a college degree and a functioning conscience, and she chose a mortgage over her nephew. Dr. Kendra Salas agreed to testify without hesitation. She was 41, board-certified behavioral analyst. She had been EMTT's ABA therapist for 2 years and 3 months. She had session notes for every visit, progress charts updated quarterly, and a professional opinion backed by 712 hours of direct observation. Her records painted a picture that Diane's petition tried to erase. EMTT's vocabulary at age 4, 40 words. At age 6, 212, self-regulation skills had improved from requires constant redirection to self-redirects with prompting in 80% of observed scenarios. His sensory accommodations at home were described in her notes as exemplary and developmentally appropriate. Margaret and I met with her in Margaret's office. Dr. Salas brought her own binder. It was thicker than ours. Removing this child from his primary caregiver would be clinically harmful, she said. EMTT's progress is directly linked to the consistency and structure that Lee has built. Disrupting that environment would likely result in regression. Margaret nodded. We do not just need to show that Lee is a good mother. We need to show that taking EMTT away would hurt him. Dr. Salas looked at me. Can they really take him? I had asked Margaret the same question. Not if I have anything to say about it, Dr. Salas said. The same words Margaret had used. 2 women, 2 different fields, the same answer. Dr. Salas did not just know EMTT's diagnosis. She knew his favorite color was green. She knew his bedtime song was the one about the train. She knew he liked his water at room temperature, not cold, and that he preferred the left swing at the playground because it was closer to the fence. She knew my son, and she was going to tell a judge exactly who he was. The phone records arrived on a Friday. Another manila envelope dropped on Margaret's desk by a courier at 11:40 in the morning. I knew what they would contain. I had subpoenaed enough phone records in 8 years to know the format. Call logs, text message transcripts, timestamps down to the second. What I did not expect was the group text thread. Diane, Gerald, Brooke, Pauline, Derek, all 5 of them in a single thread, started 11 weeks before the petition was filed. Margaret read the first message out loud. Diane to the group, dated September 3rd. We need to file before she gets suspicious. Everyone needs to submit their statements by the 15th. Gerald to Diane, September 8th. Pauline says she will say she saw bruises. Is that enough? Brooke to Diane, September 14th. What exactly do I say? I have not been to her house since October. Diane to Brooke, same day, 14 minutes later. Say you visited in January. Say the boy was screaming and she was in the bedroom with the door closed. I read the transcripts at my kitchen counter, the same counter where I had opened the petition 6 weeks earlier. Gerald's voice played in my head, rehearsed, smooth. You can't handle a difficult child as a single mother. He had not been offering an opinion at that Sunday dinner. He had been reading from the script. Margaret set the transcripts down and looked at me across the conference table. This is not just a bad petition, Lee. This is conspiracy to commit perjury. They coordinated their statements. They coached each other on what to say. They fabricated dates, locations, and observations. And they did all of it in writing. She picked up her phone and called the forensic accountant. I need the offered financial records by Monday. 11 weeks. They had spent 11 weeks planning how to take my son. I had spent 8 years learning how to stop them. The evaluation was the clearest fraud of all. Margaret subpoenaed Dr. Harold Moss's original patient files through his former practice's records custodian. The file arrived in a sealed folder with a chain of custody stamp. Inside was the original evaluation he had conducted on EMTT dated 2 years earlier. 4 pages. We placed it next to the evaluation submitted to the court. Same letterhead, same patient name, same doctor's signature, but different dates, different conclusions, and an added paragraph that did not exist in the original. The original read, "The child is well cared for. The home environment is appropriate for a child with his developmental profile. The primary caregiver demonstrates understanding of the child's needs." The court version read, "The child requires a more structured environment with multiple consistent caregivers. The current single-parent arrangement may not provide adequate support for the child's long-term developmental trajectory." Same document, same signature, different words. Someone had altered a signed medical evaluation and submitted it to a family court as evidence. Margaret deposed Dr. Moss on a Thursday afternoon. "Dr. Moss, did you write the paragraph on page 3 beginning with 'the child requires a more structured environment'?" "No, I did not write that." "Did you authorize anyone to add language to your evaluation?" "No. Do you recognize the formatting of the additions?" He paused, looked at his hands. "It looks like it was added using a standard home printer. The font is slightly different. The spacing does not match the rest of the document." Margaret showed him a sample document from Diane's church volunteer records. "Does this formatting look familiar?" "It does." My mother had altered a medical evaluation with the same printer she used for church bulletins. She had taken a doctor's honest assessment of my parenting and rewritten it to say the opposite. Margaret's forensic accountant delivered the financial records on a Monday morning. 2 folders, one for the trust, one for Diane and Gerald. The trust was clean, every disbursement documented, every receipt filed. Annual court audit spist without comment for 3 consecutive years. Diane and Gerald's finances told a different story. 3 years ago, they had taken a reverse mortgage on their home, the kind of loan where the bank pays you monthly and the bill comes due when you sell, move, or die. Diane and Gerald were not selling. They were not moving, and the bill was coming due in 14 months. The balance owed $112,000. If they gained custodial rights over EMTT, they could petition the court to be named co-trustees of his special needs trust. $640,000, more than enough to pay off the reverse mortgage, covered Gerald's medical bills from his knee replacement, and fund whatever retirement they had failed to plan for. The timing clicked into place like a deadbolt. Diane received the reverse mortgage renewal notice. Diane started the group text thread. Diane filed the petition. Diane submitted the false CPS report. Diane altered the medical evaluation. Every step pointed to the same destination, not EMTT's bedroom, EMTT's bank account. She had not asked about the trust fund out of grandmotherly concern. She had asked because she needed it. Every how is the money being managed had been reconnaissance. Every shouldn't family have oversight had been a rehearsal. She did not want my son. She wanted his money. And she was willing to call me an unfit mother in a court of law to get it. $640,000. That was what EMTT was worth to her. Not as a grandson, as collateral. Diane called me on a Wednesday night. 9:22. EMTT was asleep. I was reviewing exhibits. Her voice came through the phone in 3 stages. First the tears, then the apology, then the threat. Lee, sweetheart, this has gotten out of hand. I never wanted it to go this far. Can't we just sit down as a family and work this out? I held the phone and waited. Drop the countersuit. We will withdraw the petition. No court, no lawyers. Nobody needs to know about any of this. The CPS report is already on file, Mom. That does not disappear because you ask nicely. Silence. 3 seconds. Then the voice changed. Harder, drier. The real Diane underneath the grandmother costume. If you take this to trial, I will make sure everyone at your firm knows what kind of daughter you are. I will call Margaret Barrett directly. I will tell her that you are the problem in this family, not me. Go ahead. Margaret already has your phone records. 4 seconds of nothing. Then she hung up. I saved the voicemail, forwarded it to Margaret, added it to the evidence folder. Exhibit 23. She had cycled through 3 emotions in 90 seconds. Sad, sorry, then furious. I had seen this show since I was 12 years old. The tears were always the opening act. The apology was the intermission, and the threat was the main event. The difference now was that I had a case number, a court date, and 47 exhibits that documented every lie she had told. Diane thought she was negotiating. She was just adding evidence to our file. I went back to my exhibits, highlighted a line in Exhibit 14, set a tab marker on the page, turned off the kitchen light, and went to bed. Gerald came to my door on a Sunday afternoon, unannounced, no call, no text, just his truck in my driveway and his fist on my screen door. I did not let him in. I stood in the doorway with my hand on the frame. Your mother is a mess, Lee. She cannot sleep. She cannot eat. You are tearing this family apart. I filed a response to a petition that you filed against me, Dad. I did not start this. He shifted his weight, looked past me into the house. Where is EMTT playing in his room? That boy needs 2 people racing him. You cannot do this alone. I have been doing it alone for 3 years, Dad, and I have been doing it well. Crossed his arms, the same posture from the hallway at Sunday dinner. Same stance, same rehearsed confidence. You think you are better than us? I think I am done. Please leave. He stared at me. I stared back. He was taller, broader. He had spent 40 years in construction and his hands were the size of dinner plates. But I was standing in my own doorway in my own house, a house I paid for with a salary I earned while raising a child he called difficult. This is not over, he said. You are right. It is not. See you in court. He turned and walked to his truck. I closed the door, locked it, pulled out my phone, and texted Margaret. Gerald came to the house. Sunday 2:14 in the afternoon, documenting. He stood on my porch like he owned it. But this was my house, my name on the deed, my key in the lock, and I decided who walked through the door. Margaret and I spent 3 weekends preparing Fortriel. Saturday mornings at the office. Coffee from the gas station across the street, because Margaret refused to own a machine that cost more than her first car. Case files spread across the conference table. Stye notes in 6 colors. A whiteboard with a timeline that stretched from September to the present. The evidence binder was 47 exhibits thick. Phone records, credit card statements, travel documents, Instagram screenshots, CPS report narratives, the original and altered medical evaluations side by side, voicemail transcripts, financial records, reverse mortgage documents, Exhibit 14. The group texted and tabbed with red markers. Margaret rehearsed her cross-examination questions for each witness. She practiced them on me while I played the witness. She asked each question 3 different ways until she found the version that left no room to hide. The hardest part of preparation was my own testimony. I had to talk about EMTT's needs, his challenges, his daily schedule, his progress, and I had to do it without crying. Margaret coached me the way she coaches every client before trial. They want to paint you as emotional and overwhelmed. You walk in there like you walk into this office every Monday morning. Organized, prepared, calm. You answer the questions you are asked. You do not volunteer. You do not argue. And if you feel the tears coming, you breathe through your nose and look at the back wall until it passes. The night before trial, I read EMTT his bedtime story, the one about the train that goes up the mountain. Heffel asleep with his headphones on, curled on his left side the way he always slept. 47 exhibits, every lie they told documented, every date they faked, cross-referenced. Every text message printed and tabbed. Tomorrow morning, Lee walks into that courtroom with 47 exhibits and one attorney who has never lost a custody case. Her mother walks in with 4 witnesses whose stories are about to collapse. If you want to see what happens when the judge reads Exhibit 14, stay right here. Benson County Family Court. Courtroom B, Tuesday morning, 9:15. I arrived 40 minutes early. Navy blazer, hair pulled back, evidence binder centered on the respondent's table, legal pad to the right, 2 pens, black ink, because Margaret taught me to always carry a spare. Diane and Gerald entered at 9:10. Their attorney walked between them, a general practice lawyer named Stephen Birch. I had looked him up. Wills and estates, small business contracts, 3 DUI cases, 0 custody trials. Diane wore a cream cardigan over a floral blouse. Her church outfit, the one she wore when she wanted people to believe she was kind and soft and worried about the right things. She carried a tissue in her left hand, preloaded sympathy. Gerald wore a blue sport coat that did not fit. He had not worn a suit since my wedding. Brooke sat in the gallery, second row, arms crossed. She did not look at me. Aunt Pauline appeared on a video screen mounted to the wall. Tampa. She wore reading glasses and sat in front of a bookshelf that looked deliberately arranged. The court reporter took her seat. The bailiff stood by the side door. The clerk announced the case. Judge Richard Calloway entered from chambers. 30 years on the family court bench. Gray hair, bifocals, a face that looked like it had heard every lie a parent could tell and was tired of all of them. This court is here to determine the petition for grandparent custody rights filed by Diane and Gerald Offord concerning the minor child Emmett Offord. Diane leaned over to her attorney and whispered it loud enough for the first 3 rows to hear. We are doing this for EMTT. My mother wore her church clothes to court, the same clothes she wore when she wanted people to feel sorry for her. Brooke took the stand first. She read her declaration aloud, the way witnesses do when their attorney wants the words on the record. Her voice was flat, rehearsed. I have personally witnessed the child crying for extended periods while Lee ignored him in another room. Margaret stood, buttoned her jacket, walked to the podium. Miss Offord, when was the last time you visited your sister's home? Brooke glanced at Diane. January of this year. Yes. Margaret picked up a printed page. Your Instagram account shows posts geotagged to Cancun, Mexico from January 8th through January 22nd. Your credit card statements, which are entered as Exhibit 9, confirm hotel charges in Cancun during that same period. Brooke's mouth opened, closed. Would you like to revise your answer? Brooke looked at our mother. Diane stared straight ahead, did not turn, did not blink. The way a captain looks forward when the lifeboat is already launched and there are no seats left. Brooke said nothing. The court reporter typed the silence. Aunt Pauline appeared next on the video screen. She adjusted her glasses and read her declaration. Bruises on EMTT's arms. March 12th. Margaret did not look up from her notes. Ms. Dressler, your Delta Airlines boarding pass entered as Exhibit 11 shows you flew from Tampa to Philadelphia on March 28th, 16 days after you claim to have seen these bruises. Your hotel checkout receipt from Tampa confirms you were still in Florida on March 12th. She paused. Would you like to explain how you observed bruises on a child in Pennsylvania while you were in Florida? The video screen went black. Pauline disconnected. Judge Calloway looked at the blank screen, then at Diane's attorney, then back at the screen. He did not say a word. Cousin Derek took the stand next. He wore a wrinkled shirt and kept pulling at his collar. He read his declaration, alcohol. Multiple occasions. Lee appeared unable to care for the child. Margaret stepped to the podium. Mr. Dressler, how many times have you visited Lee Offord's home in the past 2 years? Several. Could you be more specific? A few times, maybe 4 or 5. Margaret placed a printout on the podium. Lee Offord home security camera system logs every visitor who approaches the front door. In the past 24 months, the system has recorded 0 visits from you. Not one. Would you like to reconsider your testimony? Derek looked at his hands. It might have been at a family gathering. At which gathering? We have attendance records for every family event hosted by Diane and Gerald Offord in the past 2 years provided through Discovery. Your name does not appear at any event where Lee was also present. I may have been mistaken. Margaret let the words hang in the air. Then she moved on. Dr. Moss did not appear in person. His deposition was read into the record by the court clerk. Straightforward. He admitted signing the original evaluation. He denied writing the additions. He identified the formatting as inconsistent with his practice's documents. He confirmed that the alterations matched a home printer, not a medical office system. 4 witnesses, 4 declarations, not a single one survived cross-examination. Stephen Birch, Diane's attorney, requested a recess. Judge Calloway looked at him over his bifocals for a long 3 seconds. Denied. Counsel, are you prepared to present additional evidence, or shall we proceed to the respondent's case? Birch sat down. He looked like a man who had just realized he was in the wrong courtroom. Margaret stood. She did not rush. She buttoned her jacket the way she always did before a closing argument. Top button first, then the second. Then she picked up the evidence binder and walked to the center of the courtroom. Your Honor, I would like to direct the court's attention to Exhibit 14. She opened the binder to the tabbed section, red marker, the pages I had highlighted 3 weekends ago. Exhibit 14 is a transcript of a group text message thread involving all 5 individuals who submitted declarations in support of the petitioner's custody petition. The thread was initiated by Diane Offord on September 3rd and continued for 11 weeks prior to the filing of the petition. She read Offord to the group September 3rd. We need to file before she gets suspicious. Everyone needs to submit their statements by the 15th. Gerald offered to Diane Offord September 8th. Pauline says she will say she saw bruises. Is that enough? Brooke offered to Diane Offord September 14th. What exactly do I say? I have not been to her house since October. Diane offered to Brooke Offord. Same day, 14 minutes later. Say you visited in January. Say the boy was screaming and she was in the bedroom with the door closed. The courtroom was silent. Not the polite silence of a courtroom at rest. The airless silence of a room where everyone has just heard something they cannot unhear. Margaret closed the binder. These messages, Your Honor, demonstrate a coordinated effort to fabricate evidence, suborn perjury, and abuse the grandparent rights statute for financial gain. She turned to Diane's attorney. Counselor, were you aware that your client's witnesses were coached via group text message? Stephen Birch looked at Diane, then at the judge. I was not aware of these messages. Margaret was not finished. Your Honor, the court may be asking itself why. Why would 2 grandparents coordinate perjury, fabricate a CPS report, and alter a medical evaluation to take custody off their grandson? She opened a second folder, the financial records. Diane and Gerald Offord took a reverse mortgage on their home 3 years ago. The balance owed is $112,000. The renewal deadline is 14 months from today. They have no other significant assets. Gerald offered medical bills from a recent knee replacement total $31,000 unpaid. She set the documents on the podium. If the petitioners are granted custodial rights over the minor child, they become eligible to petition the court for co-trusteeship of the child's special needs trust. That trust currently holds $640,000. She let the number sit in the room. The petitioner's reverse mortgage renewal, the petitioner's unpaid medical bills, the child's trust fund, the timeline of the petition filing. Your Honor, the math speaks for itself. Margaret stepped back from the podium. This petition was never about the child's well-being. It was never about grandparent rights. It was about $640,000 that belongs to a 6-year-old boy with autism who cannot speak for himself in this courtroom. Diane's face changed. The soft creases around her eyes, the worried grandmother expression she had worn since she walked in. It dropped like a curtain at the end of a bad play. What was underneath was harder, older caught. Gerald stared at the table, his big hands flat on the surface, not moving. The numbers did not lie. The petitioners did. Judge Calloway removed his bifocals, set them on the bench, picked up Margaret's brief, and opened it to a page he had already marked with a yellow tab. He read one line. The petitioner's text messages attached as Exhibit 14 constitute primazia evidence of perjury and conspiracy to commit fraud upon this court. He looked at Diane. Mrs. Offord, this court does not often see the level of coordinated dishonesty that has been presented here today. You filed a petition for grandparent custody rights. You submitted a falsified medical evaluation. You orchestrated 4 sworn declarations that this court has now determined to be fabricated. And you filed a report with Child Protective Services that the investigating caseworker has flagged as retaliatory and unfounded. Diane started to stand. Your Honor, please, we were doing this for EMTT. We were trying to protect our grandson. A single mother cannot. Mrs. Offord, sit down. She sat. Her hands were shaking. The tissue in her left hand was shredded into small white pieces on the table. For 1 second, she looked like a frightened old woman. Not a schemer, not a manipulator, just Somion who had gone too far and could not find the way back. That second passed. I am referring this matter to the district attorney's office for criminal investigation. Gerald's chair scraped the floor. This is ridiculous. She is our grandson's mother. You cannot, Mr. Offord, sit down. The judge nodded to the bailiff. Mrs. Offord, based on the warrant issued this morning by the district attorney, you are being placed under arrest for felony perjury and filing a fraudulent report with Child Protective Services. The bailiff approached Diane's chair. Diane looked at me across the courtroom, across 34 years of audits and inspections and corrections and control. For the first time, I looked back. The handcuffs clicked. Brooke gasped from the gallery. Gerald put his head in his hands. I did not move. Did not blink. Sat with my hands folded on the table the way Margaret taught me. Quiet, still done. Judge Calloway waited until the bailiff escorted Diane through the side door. Then he addressed the courtroom. The petition for grandparent custody rights filed by Diane and Gerald Offord is denied. Denied with prejudice. This petition may not be refiled. He turned a page. Sole legal and physical custody of the minor child EMTT Offord remains with the respondent. Lee Offord a permanent restraining order is hereby issued against Diane Offord and Gerald Offord. No contact with the minor child without the express written consent of the custodial parent and the prior approval of this court. The court further awards attorneys' fees and costs to the respondent under Rule 11 sanctions. The petitioner's counsel is directed to calculate and submit the total within 30 days. He closed the file. This court takes the fabrication of evidence and the abuse of the grandparent rights statute with the utmost seriousness. The referral to the district attorney's office stands. This hearing is adjourned. The gavel came down once. Margaret placed her hand on my shoulder. One squeeze, then she began packing the evidence binder. I pulled my legal pad toward me and wrote down the ruling, word for word. Sole custody, permanent restraining order, Rule 11, sanctions, denied with prejudice. It was what I did. It was what I had always done. Document everything, write it down. Make it real on paper so nobody can tell you it did not happen. The courtroom emptied. I was the last one to leave. The hallway outside courtroom B smelled like floor cleaner and old coffee. Margaret walked beside me. Her heels clicked on the tile. Mine did not. Flats. She had told me once that heels are for closings, flats are for trials. I never asked her to explain. You okay? Ask me tomorrow. She nodded. She understood that some answers need 24 hours to become honest. Outside, the parking lot was half empty. Midday sun, a breeze. I did not remember being there this morning. Brooke was standing by my car. She had been crying. Her mascara had run in 2 lines down her cheeks, and she was holding her phone like she had just read something terrible on it. Lee, I am sorry. I did not think it would go this far. I unlocked my car, set the evidence binder on the passenger seat. You signed a sworn statement, Brooke, under oath. You knew exactly how far it could go. Mom says a lot of things. You chose to listen. I got into the car, closed the door, adjusted the mirror, started the engine. I did not look back. In the rearview mirror, Brooke stood in the parking lot with her phone in her hand and her mascara on her cheeks. She looked small, not young, just small. I drove to EMTT's therapy session. It was a Tuesday. Tuesdays were ABA days, and no matter what happened in a courtroom, the schedule did not change. Gerald called me once, 2 weeks after the hearing. I was folding laundry. EMTT was watching a video about trains on his tablet with his headphones on. Your mother is facing prison time, Lee. Are you satisfied? Are you asking me that as a question or as an accusation? He hung up. The district attorney's office charged Diane with 2 felonies, perjury in the 1st degree, filing a fraudulent report with Child Protective Services. Each charge carried a maximum of 5 years. Brooke was charged as an accessory to perjury. Her arraignment was scheduled for the following month. Aunt Pauline received a summons to appear before the court for providing a false sworn declaration. She hired her own attorney in Tampa. Dr. Moss surrendered his retired medical license voluntarily. His attorney issued a statement saying Dr. Moss was unaware that his evaluation had been altered and that he cooperated fully with the investigation. The medical board accepted the surrender without further action. Gerald was not charged, but he was named as a co-petitioner in the referral. The investigation was ongoing. He did not call again. Brooke's house deal fell through. The mortgage broker withdrew the application when the cosigner became unavailable. It is difficult to cosign a loan from a holding cell. She sent me a letter 3 weeks after the hearing. 8 pages, handwritten, blue ink. I read it once sitting in my car during EMTT's therapy session, parked in the lot behind Dr. Solis's building with the engine off and the windows cracked. The letter was mostly about Brooke, what she had lost, what she had sacrificed, what she wished I understood about the pressure Mom had put on her, how she felt trapped, how she did not know it was illegal, how she thought it would just be a hearing, not a trial, not charges, not this, 8 pages. Not once did she mention EMTT by name. She wrote about herself for 8 pages. She wrote about Mom. She wrote about the house. She wrote about money and lawyers and fear. But she could not write 1 line about the nephew she had almost helped take away from his mother. I did not reply. I folded the letter, put it in the evidence binder, and filed it under personal correspondence. Habit, I suppose, document everything. I changed my locks the week after the hearing, not because I was afraid, because I was finished waiting to be afraid. I updated my emergency contacts, removed Deanne, removed Gerald, added Margaret Barrett and Dr. Kendra Solis. I called EMTT's school and removed my parents from the approved pickup list. The secretary asked if I wanted to add anyone else. I said no. I filed the restraining order paperwork myself, knew every line by heart, had filed dozens of them for Margaret's clients over 8 years. This time the name on the form was my own. The trust fund remained solely in my name. I added a provision with the court's approval. If anything happened to me, trusteeship would transfer to Dr. Solis and Margaret Barrett, not family. The court approved it without objection. I did not build walls. Walls are for people who are afraid of what is outside. I built doors, doors with locks, doors that I controlled. Doors that opened when I decided they would open and stayed shut when I decided they would stay shut. My house, my son, my rules. For the first time in 34 years, nobody was auditing. That evening, I picked EMTT up from his ABA session. He came through the door of Dr. Solis's building the way he always did, backpack on, left strapped slightly loose because he preferred it that way. One hand holding a green folder with his session notes inside. He walked to the car, not running. Running was still new, but faster than walking, a pace that meant he was happy the session went well. I opened the door. He climbed in. I buckled his belt and put his headphones on. He leaned into my shoulder and pressed his forehead against my arm, his signal for, "I am heard and you are safe." He did not know what had happened in court. He did not know about the petition or the CPS report or the text messages or the handcuffs. He did not need to. He knew his schedule. He knew his oatmeal. He knew his swing was in the spare bedroom and his weighted blanket was folded on his bed. He knew his mother was there every morning at 6:50 to put his headphones on and every afternoon to take them off. EMTT did not need me to fight for him loudly. He needed me to fight for him correctly, and I did. The people who were supposed to protect us used every tool they had to tear us apart. But I had tools, too, and mine were built on truth. That is my story. One petition, 4 false witnesses, and a courtroom where the truth finally got to speak. If this story reminded you to trust the process or to trust yourself, share it with someone who needs to hear it. Drop a comment, hit subscribe, and I will see you in the next.